Hello, and welcome to episode 54 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I am not Josh DeHaas, as you may have surmised from my voice. I'm Joanna Barron, Executive Director of the Canadian Constitution Foundation. Josh is away, and from the looks of his Instagram feed, he is having a hell of a time in Japan.
I'm so jealous. And I'm Christine Van Gyn. I'm the CCF's litigation director. I am not in Japan. I am in my basement in Toronto.
Yeah, poor us. Today, I'm going to talk about the growing and increasingly dramatic strike situation at my alma mater, McGill Faculty of Law.
And I'm going to talk about a freedom of expression battle at Niagara Regional Council that has a victory? Question mark.
Question mark. And as always, we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. So why don't I kick us off? McGill's law professors are on strike, and there's some background to this. The profs held a 2-month strike this spring after classes ended, but this time they are taking a more aggressive and disruptive approach. Classes were supposed to start last Wednesday, but instead there's pickets, and there seems to be like a bit of a barbecue festival situation going on in the lawn at the law faculty. And so I have some personal interest in this because obviously I went to McGill Law. I also went to McGill for undergrad. So basically I spent 10 years on that campus, and seeing some of the images and tweets, it's like, oh, that was my business associations professor. That was my con law professor. And it's interesting to see that they're kind of going savage mode, especially against the dean, but I'll get to that in a moment. But it's also substantively an interesting case, and we have a recent decision that just came down the last few days. First interesting fact is that the Faculty of Law at McGill is the first group of professors to unionize at the whole university, although non-faculty staff, so admin staff, they are unionized. And since the law faculty union was formed in the last year, the faculties of education and arts have also filed for union certification. So this is sort of like a domino effect, which I think explains a lot of why McGill is trying so hard to fight this. One law prof commented that the law professors' fight will determine the future of unionization at McGill. So, a major university, a lot is at stake. And I suppose if one group of profs are going to go through this first, you want the law profs to do it, they make very good arguments. They're very good at speaking to the media. They understand the scope of labor law. And so the university is trying to quash the movement. They are challenging the certification of the union. But first, let me talk a bit about this recent decision that came down 2 days ago from the Labor Tribunal. So this is an interim decision that basically concerns what I believe are called union busting techniques that the administration has been engaged in. And the Labor Tribunal ordered McGill to stop obstructing and stop interfering with a union that represents full-time law professors. They found that the university, at least at first appearance, because this is an interim order, violated the Quebec Labor Code when the administration sent 2 emails in the lead up to a union meeting, so not coincidental timing. They sent 2 emails to the law faculty criticizing the union in the days before they decided to resume an unlimited strike coinciding with the start of classes. And basically, the union was able to show that these were union-busting tactics. McGill was seeking to influence its members on the eve of the general meeting, and the tribunal agreed that the emails attempted to undermine the union's credibility at this very sensitive moment. So just briefly, the 2 emails were first from the provost of McGill, Chris Manfredi, as well as the VP of admin, and was sent to the law professors by the dean. The second was an explanation why McGill had withdrawn from negotiation, and the tribunal critiqued it as being tendentious and containing comments that criticized the union's approach. And then a second email was sent the following day, and it was a correction email, and it claimed that the union document, I guess, outlining the union's demands and the reasonableness of their demands, it alleged that the union document contained factual errors, omissions, and misrepresentations. So the tribunal ordered McGill to basically stop this, to cease all forms of obstruction, to refrain from interfering in union affairs, other than in a factual neutral means, which I suppose McGill was arguing that this was factual and neutral, but nonetheless, McGill has agreed that they will abide by the decision. So despite these attempts to get the union to rethink their tactic, the law professors, of course, decided to go back on strike. And the Labor Tribunal has certified the union in 2022, but the union is still in bargaining. They have not secured their collective agreement. And it looks like McGill, when the hearing on the merits goes forward, is going to challenge the certification of the union. So, not being an expert in labor law, I looked into a little bit about this, and McGill has, of course, not said on what basis they're challenging the certification of the union. So I looked into it, and this is my guess. So the process for certifying unions as collective bargaining agencies requires that a majority of employees in what is called an appropriate bargaining unit wish to be represented by that union. So it looks like McGill Law, they have the appropriate sort of quota, the number of law professors that are indicating a desire to be unionized. But I would think, reading between the lines, especially on some of the union itself's materials, what McGill might be going after is the viability of the law faculty itself, as opposed to, let's say, all of the professors, all full-time faculty at McGill University being an appropriate bargaining unit. And this is actually very unusual in Canada. So it's unusual for individual faculties as opposed to faculties as a whole at Canadian universities to be unionized. So I think this might form part of McGill's objection. So there are a few exceptions that the law faculty union is highlighting. A big one is Osgoode Hall, which has a faculty association just representing the law school. There are also a few engineering faculties in Quebec that have their own unions. But for the most part, university professors either are not unionized or they have sort of pan-university unions. So McGill might just say, look, for some reason, this has not been the practice, and so you shouldn't certify. If all of the professors want to unionize, that would be a different thing. And McGill's faculty has some answer to this on their website. They say basically the reason why they think they should be certified as their own union is that basically they're special. They say the Faculty of Law is distinctive with a common intellectual project, which we afford and which we are proud of. We're subject to external accreditation. We have significant obligations identified in the Truth and Reconciliation Commission. And so I actually think they have a decent argument that this is a quote unquote appropriate bargaining unit based on what I saw of the criteria of an appropriate bargaining unit. Then there's this other matter, which I won't even get into, about the right of basically public sector employees, which essentially McGill faculty are, to strike. It attracts different considerations than employees of private employers, because the question of their salaries, which is really what is driving this, and I'll get into this in a moment, is not determined by the market, but it's determined by government budgets. And so public sector unions can functionally act like rent-seeking cartels to extract goodies. But of course, the SEC decisions, Saskatchewan Federation of Labor, famously did away with that argument. So I suppose constitutionally, they do have the right to strike. So the last thing I'll say, because I know I've been going on, but this just gets more and more fascinating to me the more I read about it, is that, of course, the core of the demands is about money. On the website, they have a graph up, which shows the delta between average salaries of McGill law profs as compared to University of Toronto law profs. which I think normally U of T is ranked the top law school in Canada, and McGill is either second or third, kind of like sometimes interchanges with Osgoode. And they show that the average professor U of T in law, their salary is now touching about $300,000 a year as of the last year. And McGill's average law professor makes about 200K. So not the most sympathetic that they're not content with their $200,000 average salary, but whatever. I won't get into that, but just a few comments on the fact that, of course, they're picking U of T as the comparison. U of T has by far the highest salaries of any law faculty in Canada. Osgoode Hall would probably like to have something to say about this, particularly because their professors also have to deal with the cost of living in the Greater Toronto area, which is, yes, I know real estate and cost of living in Montreal has gone up, but it is still far, far more affordable than Toronto. And then second of all, and I just pulled this just for clarity, U of T's law tuition for domestic Canadian students in Ontario is $33,000 a year. Outside of Ontario, $37,000 a year. McGill's tuition, $9,000 for non-Quebec Canadians. $3,000 for Quebec resident Canadians. And by the way, U of T's faculty is not unionized. So I think that there are factors other than their union or non-union status that are driving at the delta in salaries between U of T and McGill. So anyways, it's gotten pretty acrimonious. I've seen like my professors going after the sort of prominent and much admired and much feared Dean Robert Leckie, who I was a research assistant for and is just one of the most brilliant jurists. But anyways, they're complaining that his salary went up by 65% in the last 5 years, and theirs have barely kept up with inflation. So the gloves are definitely off at McGill. Christine, I know that you haven't, you're not as much in the weeds about this. So having heard this whole drama, what are your thoughts?
I mean, the poor students, except for the third years who are probably like, woohoo, no class, because they mostly probably already have jobs and don't really care at this point.
Yeah, but they have to like get their credits
They
in
have,
law school to
do.
get to those jobs.
For
Yeah.
sure they do. I just think, I mean, it's really probably a big problem for first year students and for second year students who are supposed to be going through the interview process and trying to get grades in to help them with the interview process. So I actually did experience not a strike from the law faculty, but when I was in first year at Osgoode, there was a strike by the teaching assistants. And so
Mhm.
I had some professors, actually just one professor who I love, by the way. We work with him sometimes. He did not want to cross the picket line of the teaching assistants, even though he didn't have a teaching assistant. So like, I guess solidarity.
Yeah.
But he didn't want to cross the picket line. So he did all of his lectures for this one first year course that I had him for. He did it all by video recording. And at the time I was like, oh, this is so strange and weird. But now that's what first year law was like for everyone in 2020 and I guess part of 2021, I think.
Maybe even
So
2022 because a lot of
yeah,
the cops did not want to go back.
so he was a trailblazer, but originally for solidarity reasons instead of pandemic fear reasons. But it was not like especially disruptive because we still got our lectures. But I do feel really bad for these students. Many of whom will not go on to have $300,000 or even $200,000 salaries, depending on the field of law that they decide to go into. That would be at the very high end of what you would earn as a criminal defense lawyer or even potentially a family lawyer or a sole practitioner. So, I mean, it's not
And with
it's,
and without summers off and sabbaticals.
yeah. So, I mean, I don't really. I think it's like not a great message to the students from their faculty, especially when you're just being introduced to this profession. And then even the argument that they've put on their website that you described, Joanna, of why they should be certified. It's just like the most quintessential law egocentric argument of we are special, we are different, we should have certification as our own group because of how special we lawyers are. Like, go away. I hate
Yeah.
arguments like that. It just gives me it represents all the things that people don't like about lawyers. So and about the profession of this sort of self-importance. Anyway, that's kind of my take. My heart goes out to the students, and I don't find it especially sympathetic to think about people with six-figure salaries complaining that they're not paid enough, especially when they're
Multi six figures, and they get to
yeah.
live in Montreal, which, yes, I lived in Montreal for many years, and your dollar goes a lot further there.
And they're comparing themselves to like the highest income comparator group, which is U of T. So just I don't like it. And I'm mostly concerned for the students because we work with students all the time in our internship program. I just feel bad for them
Yeah.
to have this introduction to the whole system be so negative.
Apparently, yesterday they were doing a teach-in on the front lawn about the Quebec Labor Tribunal decision, the very important decision in favor of the union. So I'm sure the students feel great about that.
Yeah. Anyone who went to that probably is already sympathetic to that cause. Like they just probably want to learn business associations and constitutional law so that they can get jobs and graduate.
Yeah.
Anyway, let's turn to my headline now, which is something that we've been working on here at the CCF. So, speaking of self-important, I'm going to talk about ourselves now. So, this is a freedom of expression issue from a local government. This is from Niagara Region. So, in July, Niagara Regional Council proposed changes to their procedural bylaw. And these proposed changes would impose a blanket ban on flags, signs, and props from being in council chambers. So, like, nobody in the gallery could have flag signs or props. And this was all precipitated from a meeting in January that had been especially difficult and it kind of spiraled out of control. So, as a result of that January meeting, council wanted to change their internal processes to improve decorum in meetings and allow them to regain control. So, the January meeting, for context, it had involved a motion by one regional counselor about Israel's war on Hamas. This was Counselor Haley Bateman, and she brought a motion calling for a ceasefire in the war, asking for lighting Niagara's headquarters, the regional headquarters, in the colors of the Palestinian flag, and asking the feds to remove the cap on Palestinians from Gaza coming to Canada, as well as asking the feds to give these people from Gaza social assistance when they come to Canada. So there was another motion in response to this ceasefire motion to remove it from the agenda because they said that the conflict in Gaza, quote, does not pertain to Niagara region business or its mandate. And I mean, obviously, it clearly does not.
Mm-hmm.
The problem, though, was that there had been a different motion, I think a year or maybe a year or two prior, about Russia's war on Ukraine. And so there had been a debate about that. So some people in the gallery and this counselor perceived this as giving preference to acknowledging one conflict, but not another. And on that, I do see the point. I also think, though, that this whole thing is crazy. These local councils will not have any impact on either the war in Gaza or the war in Ukraine. They should spend time on local issues, not on issuing statements about foreign wars they have no impact on. But, I digress.
Mm-hmm.
So there were a bunch of people in the gallery who supported this ceasefire motion, and they were there with, all of their stuff, their Palestinian flags, their keffiyehs, their buttons, their signs. You can probably imagine what it looked like. And they were all really upset when there was the motion to remove this ceasefire motion. And they got really disruptive. And the counselor who had brought the ceasefire motion was, interacting with the people in the gallery. There's a lot of shouting. The regional chair had to stop the meeting twice to regain control. So look, I get that that meeting was really out of control. It was disruptive. It was difficult. But I also think the whole issue is absurd and is honestly hijacking the regional meeting for some very remote purpose. And the council probably should not have passed the Ukraine motion either, even though that one was not really contentious because people are not as entrenched in their positions about Ukraine as they are in the Israeli Palestinian conflict. People have very strongly held positions on that conflict, and they're probably not going to change their position. And those positions all predate the conflict. Whereas the Ukrainian conflict, I think there was broad agreement that the Russia's war was unjust.
I
So
mean, in the West, but yes, okay.
in the West, yeah, in Niagara region, there was
Yes.
broad agreement that it was unjust. So council said that they wanted to make sure that their meetings in the future don't get out of control and that they're efficient and that there's decorum. So they proposed changes to their procedural bylaw that did a few things. First, it banned applause and heckling from the public gallery. It also required members of the public who were making delegations to council, so speaking to council, it required them to send their speaking notes in advance. And it also banned signs, flags, and props in the public gallery. And this proposal was made on July 25th, and I read about it and I had some concerns. I'm broadly concerned about all of the proposals, but the ban on signs, flags, and props is clearly constitutionally vulnerable. So I wrote to council and encouraged them to vote against the change. I told them in a letter I sent to them that banning signs, flags, and props would result in banning pride flags, Canadian flags, Remembrance Day poppies, yellow ribbons to honor the hostages in Gaza. It would ban buttons that ask for lower taxes. And this on its face is a violation of the right to freedom of expression. And it's important to remember that municipal and regional governments are not like parliament or provincial legislatures, which can and do have rules banning signs, flags, and props. But parliaments can make these rules because they are sovereign under our constitution, and municipal governments are not. They are creatures of provincial statute, and their decisions can be reviewed by courts for compliance with the charter. So I added in my letter that the limit on freedom of expression, this is political expression, these signs, flags, and props, that it's actually the hardest to justify when it's political expression. And in this case, it can't be justified under Section 1. If the concern is violence, if the meetings get out of control, ban signs with like hard handles or something. And there's actually case law on that point, a case from Ontario called Gammy and South Bruce. If the concern is visual obstruction in the gallery, restrict visual obstructions. But one of the regional councils said the point of banning these things is that they are, quote, distracting. And I saw many of these counselors on their cell phones during the meeting. So clearly they're willing to tolerate something much more distracting than a sign or a flag. Another counselor actually said that signs can influence the council even if the gallery is silent. And you can't see a sign again and again without being influenced. And this is the point. That's the whole point. The public is trying to influence their elected representatives. They want to be seen and heard. So that isn't even a proper purpose for banning signs, flags, and props. So I sent this letter. There was a bunch of coverage of the letter in local media. I had an op-ed published. Multiple outlets covered the issue, which is great. I love local media reporting, and there's too little of it now. But then on August 29th, the council voted on the changes, and they actually made amendments because of my letter. And they decided to ban signs with handles with hard backings. And this was directly from my letter and from that Gammy case that I cited. But what they did do that I didn't like is they still banned flags that are, quote, offensive. And this is a problem because what is offensive? Is a yellow ribbon offensive, a bring them home dog tag, and Israeli flag, are those things offensive to the counselor who brought the ceasefire motion? Is a pride flag offensive, or a sign saying stop radical gender ideology offensive? People who have different views on these things might be offended by both of these symbols. The term is just completely subjective. And what's important to remember is that the charter protects offensive speech. And it's actually the offensive speech that gives the right its meaning, because no one is trying to silence inoffensive speech. That's the whole point. So I think that the change was good, but because it's no longer a blanket ban, and we were the cause of that, like we resulted in some change because we had threatened to sue them. But I'm not convinced that the bylaw will withstand judicial scrutiny. We are still not happy with this. That's why I say victory question mark. We're still kind of deciding what we're going to do next, and if this is a big problem. I think the issue is the way this bylaw will be enforced in practice is that it's going to just be used against the people and statements that are unpopular with council. So that's a problem. Joanna, what do you think?
Yeah, I mean, it's a live issue, this question of how inherently subjective the offensive standard is. I remember a couple of months ago, people were offended that a Toronto police officer was standing next to someone and chatting with someone who was wearing an F Hamas t-shirt. People were like, this is completely inappropriate and shows they're taking a side, saying F, a literal terrorist group. So we clearly are in very strange times where all kinds of people are offended by all kinds of things, and it seems to be extremely polarized. But more broadly, we've observed just this pattern that city councils, they seem to have forgotten that the charter applies to them. I think they think that because they're creatures of statute, that they can just regulate their affairs however they see fit. And it's not true. They're creatures of statute, therefore they're empowered by statute, therefore they're arms of government, and they have to abide by the Constitution. Like we've had numerous of these, city council. I remember that guy in what was that town in Nova Scotia?
Yarmouth?
Yeah, Yarmouth. Remember there was that lawyer who was involved with the city council that was like, you have this all wrong. Like we get to make our own self-governing regulations as we see fit. And it's like, well, yes, but you still are subject to the strictures of the Constitution. Yarmouth was a case where they banned all election signs under the pretense of environmental reasons, even if they could be recycled, even if they could be on wood. And in that case, that was in 2020. You just sending a letter just got them to drop it completely. So anyways, it's very important to stay vigilant because, yeah, there is in our forthcoming book on free expression, we talk about the curse of the local tyrant, that just because government is smaller doesn't mean that it has a smaller effect on how we actually live civil liberties. And so we'll see what happens. It was also funny. I think you sent this in our group chat that there was a pro-Palestinian who was cackling at your letter, how you gave a sick burn when you were like, if you're really concerned about distracting, like we're watching the videos of these town hall meetings and everybody's like playing Wordle on their phone. And he was like, I hate these people. They're self-righteous. I don't even remember what word he used.
Sanctimonious assholes.
Sanctimonious assholes. Yes, I said we should have hats made, calling that either that or too much estrogen, which is the other complaint that has been lodged at this podcast.
Even worse this week.
That's right. Yeah. Sorry. Our testosterone is in Japan eating sushi. Anyways, so we'll see what happens. But the fact of the matter is that you have to stay vigilant at these city councils, as we've seen in Waterloo and Calgary and Yarmouth and now Niagara region.
Many cases like this.
Yes. Okay, we'll take a quick break and then we'll come back and give you our bad legal takes of the week. Okay, so my bad legal take goes to Justice Lee Akazaki of the Ontario Superior Court, who had a decision of his overturned by the Ontario Court of Appeal this week. And the Court of Appeal did an epic, what we used to call when I clerked at the OCA, bench slap of Akazaki. They say his reasons contain material errors, serious misapprehensions of the evidence, and errors of law. And I'll just give a brief overview of what happened. So this was a family law child custody decision. Couple, mother was born in Ireland, met a husband who was originally from India in England. They got married and moved to Toronto. They had a baby girl, and when the girl was 10 months old, they separated. And then the woman applied for divorce and sole decision making responsibility for the child. And she also sought to relocate to Ireland, where her family was from and where she had an optometry job waiting for her. She wasn't qualified to practice optometry in Canada. Of course, the father opposed the move, and at trial, Justice Akazaki sided with the father. And he concluded that there was insufficient evidence to show that the mother had better financial prospects in Ireland. But in his reasoning, he made some very weird moves. So there was some evidence that the father had been abusive towards the mother. And when the justice was assessing this evidence, he mentioned the fact that the father agreed to use a midwife for the birth of their child. And Akazaki said that the agreement to use a midwife was wholly incongruous with the behavior of a misogynist and a gaslighting abuser, which was not a submission made at trial. And back in the 80s and 90s, when I was born, and I was actually born at home via a midwife, it was, I guess, a sort of like feminist hippie thing. But Justice Akazaki may not be aware that midwives are fully integrated with the mainstream medical system now. Some of my hippie friends even call them medwives. So yeah, like total non sequitur. Then he had this whole other weird tangent about race, which I guess this little girl was half Indian and half Irish. He said Toronto was a superior place for a biracial person to live compared to the ethnically homogeneous Irish town where the mother was from. And he said where the child would have no effective means of resisting the assimilation of part of her identity that does not belong to that small and strict world. And again, the Court of Appeal is basically like, WTF, none of this was evidence on the record. Counsel for neither side raised this. And this is just a very simplistic, like old identitarian way of looking at things. And the last thing he did, so the mother had called the police when she alleged that the father had abused her. And Akazaki says that she used the cops as a kind of marital counseling agency when she called the police on a domestic report. He wrote that the opinion that police services can be summoned to stop a spouse from arguing offends the hard-fought gains of women's groups in Canada to reverse the historical reluctance of law enforcement to get involved. So basically, he's saying you were the girl who cried wolf. The judges say this is mocking and inflammatory. And again, like nobody asked this. Nobody asked you to make these findings. So happily, a new trial has been ordered. So Justice Akazaki, you get a emphatic bad legal take of the week. What's your bad legal take, Christine?
Okay, so I know that I always do this, but my bad legal take may not be a bad legal take. I'm not sure yet. It's kind of like a TBD bad legal take. We're going to have to see how it plays out. So, exactly 1 week ago, I was driving to St. Catharines for something that I haven't talked about publicly yet. So, this is the first time I'm telling anybody. But I was given, as part of my television program, Canadian Justice, an exclusive one-on-one interview with Frank Stronach, who is the founder of the car parts giant Magna. He's 91 years old, and he's just been charged with 13 sex crimes dating back to 1977. The charges include historic allegations of rape, which is and attempted rape, which was what it was called pre-1980, and then I think 11 other charges related to sexual offenses. So sexual assault, indecent assault, as well as unlawful confinement. So I interviewed him about his feelings about these charges, his reaction to the charges, and his lawyer was not present for the interview. He had actually recently switched lawyers. And so you're going to have to watch the interview to decide if you think this this is a bad decision or a good decision to sit down when you have serious sexual criminal offenses pending, to sit down for a television program and to be interviewed about it. The interview is going to air this Friday, Friday, September 6th. So watch it. Let me know what you think. And I think to determine if it was a good decision or a bad decision to sit down with me for an interview, really, I think it's going to come down to what happens in his trial. Although we know that the wheels of justice do turn slowly, and Frank Stronach is about to turn 92 years old. So I think part of the rationale, although he didn't say this, might be that he wants to say what he thinks about this whole situation, because he is, quite in advanced age and wants to get his message out there, maybe because he's concerned about how long the criminal justice system might take to address all of these. So you're going to have to judge for yourself if it's a bad legal take or not. I am not sure yet. But yeah, that was a really big deal for me. It was really interesting experience. I've never done anything like that before, and it was really challenging. So that's it for me.
Okay, as usual, please rate, review, and subscribe. You can make comments about estrogen dominance. We don't mind. We'll turn it into hats and t-shirts. You can support our work by subscribing to the Canadian Constitution Foundation's YouTube channel or the Not Reserving Judgment channel, by following us on Twitter, by visiting our website, theccf.ca, where you can sign up for our new and improved Freedom Update newsletter from our colleague Russ. The Canadian Constitution Foundation is a nonpartisan legal charity funded by your donations. So please click that donate button on our website if you can, and you might get a thank you call from me or Christine. Thanks so much for listening.